And no, I remember I also decided one matter there in Madras High Court, against which they carried the matter on appeal, and there is some interim order granted. Same fringe benefit tax. And there is another division bench of Justice Rajiv Shakdar when he was in Madras High Court. That also they filed.
One is arising out of an order under Section 263. The law was amended the next year. The amount which is paid to celebrities for endorsement. Whether that should be considered for the taxation under fringe benefits. They amended the law the very next year to exclude that because there's no employee benefit there.
So fringe benefit tax is not a issue here.
There's not a challenge to that. It's on the provisions as they stand and not as they were amended. There are decisions of the courts where even the before the amendment took place, the law was interpreted as subsequently amended.
We'll take it up next week. So. Give a date after the release.
See.
Yes.
But in this matter, I had handed over to my learned friend copies of the orders passed by the tribunal and thereafter by the assessing officer, giving effect to the tribunal orders.
Yeah.
And they were to take instructions.
No appeal has been preferred.
You please show the order sheet.
This appeal was against the order under Section 260. The tribunal's order upholding the order under Section 263. And then in the give effect proceedings, the matter travelled up to the tribunal. Tribunal decided in favor of the assessee, and then the officer gave effect. So in view of those, and since my learned friend says that they have accepted those orders or they are not in appeal against those orders.
What should be done to this appeal?
So then I don't need to press it in view of the position that those orders.
You can withdraw this appeal. No.
If my lords are pleased to have a look at the last order, I can.
Or we can dispose it off as no further orders are required in this appeal.
In view of
in the light of.
Yes. I think that would.
In view of the developments.
It has become infructuous in view of that.
We have taken oral instructions that no appeal has been preferred, but we have got nothing in writing.
This appeal has been filed by the SSC under Section 260 Capital A of the Income Tax Act 1961, challenging the order dated December 30, 2013, passed by the Income Tax Appellate Tribunal A Bench, Kolkata, within bracket Tribunal, in ITA number 559/KOL/2012 for the assessment year 2007-8. The appeal was admitted on 4th August 2014 on the following substantial questions of law, page 113 to 131 of the paper. We have heard so and so, so and so. The learned tribunal affirmed the order passed by the Commission of Income Tax, Kolkata 3, dated 29/3/2012, passed under Section 263 of the Act. During the pendency of this appeal,
may I quickly recap. The first order before my lords in the compilation I've handed up is an order on the miscellaneous application, whereby that order 13 December was corrected. If my lords are pleased to see the first paragraph, there it's a correction of the order of 13 December. After this order, in the meantime, the assessing officer gave effect to the tribunal's order, the 263 proceeding will give effect.
Before the correction.
Yes, not before the correction. Then then he also rectified that particular assessment order. Now the Commissioner Appeals granted relief to the assessee partly. So the revenue preferred appeal before the tribunal against that part, and the assessee preferred appeal against the part which was against the assessee. So the page with the number which is there at page 78, but that is the order passed on the assessee's appeal, whereby the appeal was allowed. My lord may notice at page 81 the appeals were allowed. And then the next the page 83 is the order on the departmental appeal. It's the DCIT versus CD Acquisition. This appeal was dismissed. Page 85, the appeal was dismissed. Then at page 86 is the order dated 10th May 2021, passed by the assessing officer. He notes the different orders, and then finally he leaves me assessed at the original return figure.
So he revised the assessment in terms of the order passed by the tribunal.
By the tribunal, and I my original figure is retained. Retained.
Admitted on so and so. We have heard the on account of certain developments which had taken place during the pendency of the appeal and the orders passed by the assessing officer as well as the tribunal, nothing further survives for adjudication in this appeal. We say so because initially the tribunal passed an order on 13/12/2013 affirming the order passed by the Commission of Income Tax under section 263 of the Act. Subsequently, a miscellaneous application was filed in MA number 13/KOL/2015 in ITA 559/KOL/2012 for rectification of the order. The learned tribunal, taking note of the contentions raised on behalf of the assessee, rectified its earlier order dated 13/12/2013 by passing an order in the miscellaneous application on 6/11/2015. Pursuant to such rectification, the assessing officer also passed an order, a rectified order.
The original, he passed the orders under pursuant to the order of the commission under section 260.
But after rectification, he didn't do anything.
No, thereafter
Then
this.
you say, thereafter, no, that sentence you delete. The assessee being aggrieved by the order of assessment as affirmed by the CIT within bracket A, order of assessment dated 28/3/2013 as affirmed by the CITA by order dated 27/2/2015, preferred appeal before the tribunal in ITA number 358 and 359/KOL/2015. The revenue also preferred a separate appeal since the CITA granted partial relief to the assessee and the revenues appeal was taken on file as ITA number 554/KOL/2017. The assessee's appeals, namely ITA 358 and 359/KOL/2015, were allowed by the tribunal by order dated 3/2/2016, and the appeal filed by the revenue in ITA 554/KOL/2015 was dismissed by the tribunal by order dated 11/5/2018. As a consequence of the order passed by the learned tribunal in the assessee's appeal dated 3/2/2016, a giving effect to order was passed by the assessing officer, namely the Deputy Commissioner of Income Tax, Circle 7 within bracket 1, Kolkata, dated 10/5/2021, which went in favor of the assessee. In the light of the above developments, no further orders are required.
But then the revenue submission that these orders have become final.
Yes. The learned senior standing counsels appearing for the department have instructions to state that the orders passed by the learned tribunal orders passed by the learned tribunal, both in the assessee's appeal and the revenue's appeal, were not challenged before this court, and they have attained finality. In the light of the above developments, no further orders are required in this appeal, and the same stands accordingly disposed of.
I'm grateful.
The substantial questions of law framed for consideration are left open.
I'm grateful.
Deeply right.
But I'm appearing for the rest.
Lord, in this matter, Lord, there's a writ petition which has been referred before my lords, and Lord, also the income tax appeals. Lord,
Right.
2 years are there, assessment years 8, 9, and 9, 10, and Lord, 7, 8, 9,
In the writ petition,
8, 9, 9, 10.
the direction of filing an affidavit has not been done. It has not
You have
been
not filed affidavit in opposition. Now, this writ petition is challenging the board's order.
Board's order, Lord. And Lord, the board has not rejected it on a very short ground. Lord, they say that Lord, the reason why I could not file the returns in time was a family dispute litigated before this honorable court. This multiple litigation, Lord. The accounts were withheld. Therefore, Lord, I could not consolidate the accounts and file it. That was the reason, Lord. The board seems to think that it was possible for me to file it, whereas Lord, the record shows that if the accounts are withheld from the company by one of the persons, so Lord, that is the ground on which Lord, the board
Suppose
has.
the writ petition is allowed, this automatically has to.
Lord, as far as the merit is concerned, Lord, I lost before the tribunal because Lord, the returns were not filed in time. So Lord, under section 80 AC, that was held against me. But otherwise, there's all the conditions for getting the exemption are satisfied. Lord, the deduction under section 80I and 80IB for 2 of the units, Lord, I also got in the earlier years. This year, because of Lord, the delay in filing the return, which was because of the litigation, Lord, it could not be filed in time. So Lord, this is otherwise short. I've prepared a list of dates, and Lord,
But if the board, if the order of the board is under challenge, the affidavit in opposition has to be vetted by the board.
Look, the facts cannot be improved upon because the board's order is speaking order. It's not that there is.
But then the local commissionerate cannot, without their consent, because it is the order impugned, as per the procedural, it needs to be vetted. It will be affirmed by the local officer, but needs to be vetted. An authorization has to be given by the board because it will cover him also. When you will file your affidavit?
They've had time from 2014 in August.
No, 2023 is the writ petition.
Yes, not
Yes.
then by the time it came, it was referred before.
The last chance, Lordship, give any subject to Lord 2 weeks. I'll communicate the order to the local people and then they'll commit.
It's in right.
3 weeks will be sufficient.
3 weeks.
The revenue is directed to file their affidavit in opposition within a period of 3 weeks from the date of receipt of the server copy of this order. Reply, if any, within a week thereafter. In the event the department does not file their affidavit in opposition within the time permitted, such affidavit will not be accepted by this court, shall be accepted by this court, subject to payment of cost of rupees 50,000 to the West Bengal State Legal Services Authority. Let us see what happens.
Order number 6.
Yes. I will make a very short submission, my lord. That appeals to my lord. I will not go in details. That this is the order against the tribunal, appeal against the tribunal. My 2 questions was framed, my lord, in this case in 2009. And my lord, the tribunal remanded the matter on various counts, on limitation, on penalty, on levy of tax, on reimbursement, levy of tax on my activity of stock, verification, bending, etc., still held that my activity is taxable under C&F agents.
It is not an open remand.
It is not a open remand. Still, they held that my activity is taxable. That's why, my lord, the first question was framed. My lord, may I read the question on October 9 December 2009 order?
Where is it there in the paper book? No.
Uh,
It's not in the book.
The second page, my lord. First question, whether the learned tribunal was justified in passing an order of remand on the issue mentioned therein after having decided the fact that the appellant is a clearing of forwarding agents. And the second question, whether on the facts and circumstances of the case, also the material placed before the learned tribunal was legally correct to conclude the appellant is a clearing forward agent. But two more submissions, my lord, that may click. The original authority relied upon a judgment of the tribunal of the larger bench in Metro for Parma. That judgment is reversed by the Punjab Haryana High Court in a Kulsip case. The tribunal relied upon their own decision in the coal handle. That is overruled by the Supreme Court in an appeal. Therefore, if my lord may point out directly to these two, that may itself suffice. Thirdly, my lord, so far as the reimbursement expenditure is concerned, the tribunal relied upon the Rule 5, which came subsequently in 2006, which I challenged before Delhi High Court, quashed that rule. Supreme Court also upheld that judgments. Lastly, my lord, so far as extended period is concerned, they rely upon the provision of 73 introduced in 2004 on 10 September. My issue is from 99 to 2004 March. And even I, my lord, succeed before my lord. Even there is a vague allegation, there is a suppression, fraud, etc. No evidence, no details, etc. I have the entire compilation, which my lord, I succeed before my lord only. There has to be some detail, etc. And secondly, whether the provision, that is a question a larger, whether the provision introduced in 2004 September could apply retrospectively for a period of 99 to 2004 March. Lastly, my lord, the same appellant, for the same very activity, I appeared before Allahabad High Court. Because I am carrying out activity in various parts, my registration was Allahabad also. The same very agreement with the TISCO, same date, I succeed before Allahabad High Court, saying that this so-called notice itself is not maintainable, because there was no allegation of section 73 which exists at a relevant point of time. Because prior to 2004 September, my lord, the extended period could have been invoked under section 73 1A if the return is filed, and after examination of the return by the superintendent, if he feel like that there is some discrepancy, he has to refer the matter to the deputy commissioner. Then deputy commissioner issue the notice, which has not been done in my case. In fact, my case, judicial commissioner carried out a search in 2002. I submitted a letter, I met them, that activity is not taxable, but nothing was done. 2004, after more than 2 years, Jamshedpur DCCI investigated the matter. They later on, the Delhi, Calcutta DCCI issued me the so-called notice. And my submission before the original authority and tribunal, they all ignored about the extended period also. They remanded back. Remand should be rarest. If my activity is already there, my facts are already there, they have to decide it. So therefore, may I straightway point out, my lord, in the appeal, what the original authority relied upon or decision in larger bench case, my lord.
Where is the discussion?
Yes, my lord, page 24, the annexure 1, this appeal paper book, page 24, that is the original order.
No, tribunal's finding.
The tribunal finding. Kindly come to the tribunal.
117.
108, my lord, page 108.
No, discussion starts at 117.
Yes, my lord, absolutely correct. Now, my lord, may I just point out one by one, because there are various findings. First one, my lord, the decision which rely upon the cargo handling, my lord. Kindly come page 121. 121. First paragraph, last 4-5 line, my lord. in case of a coal handler decided by the tribunal had also views similar to our view as aforesaid. However, the said decision awaiting the decision of the apex court. Now the decision has come that is against the
Department.
yes, my lord. Now, my lord, come to the activity 6.6 para 119. The reimbursement, my lord, may I point out the my 6.3 is written about the agreement, my lord. The record reveal that the search was conducted. This fact is absolutely incorrect, my lord, has been recorded 6.3. The search was conducted on 19/4/2002, and that brought out the material to light to the issue of so cause notice. Absolutely incorrect. So cause notice, my submission was that the so cause notice concealed this fact. So cause notice is not based upon the search conducted in 2002, because that search was conducted by the jurisdictional commissioner. This so cause notice as issued by the DGGI. They never conducted search. They start investigating. And that investigation was done by the Jamshedpur DGGI. So cause notice has come by the DGGI Kolkata. Two places it has been recorded by the tribunal that because of the search of 2002, this so cause notice has come. So cause notice has not referred even a one word. In fact, my submission before the original authority and the tribunal was these facts has never been considered. The search was carried out. I made a submission after the search that my activity is not taxable. I met to the concerned deputy commissioner. Deputy commissioner never clarified the issues, never demanded tax. And kindly see, my lord, the reimbursement also, the rule 5 they have referred, which referring to that it was introduced in 2006. Kindly page 120.
So one second. So with regard to the finding that you are a clearing and forwarding agent, the tribunal followed coal handler's case.
Yes.
Which has now been reversed.
Yes.
Then that is at page 121.
In fact, after that, my lord, to add, same appellant has succeeded.
Before Allahabad.
Not only Allahabad, in the tribunal also in other cases.
Okay. Then the second point is, you said paragraph 6.3.
Yes, my lord.
And what is, this is factually incorrect, is your submission.
Yeah. Yes.
Right. Then
6.7.
6.7.
Whether reimbursement of my expenditure will be taxable or not. The tribunal remanded back the matter, referring to the rule 5 of the Service Tax Determination Rule 2006, my lord.
See, this is a spillover or fallout of the finding that you are a clearing and forwarding agent. Suppose you succeed at that point, this automatically goes.
No, my lord, my reimbursement as per the intercontinental decision, which I succeed in Delhi High Court, approved by the Supreme Court in a detailed judgments. And in fact, that has been relied upon in other of my same party case before this High Court also, that reimbursement can never be taxable, whether the activity is taxable or not. And this rule, which was made taxable in 2006, subsequently stuck down. It was declared as ultra virus. Therefore, my lord, in fact, the tribunal has wrongly relied upon a rule which was never been in existence. The rule was Rule 6.8, which, my lord, may I just point out. It says only even if any person is indulged in the activity of this C&F agent, only the commission will be taxable. There was no scope for any other activity to be added in it. The tribunal has seriously erred by relying upon a law which was never been in existence that time. My period is 1999 to 2004 March. This rule itself came in 2006.
All right. This is the third point.
Yes.
Then
now extended period, my lord. Extended back, kindly see, that is also remanded back.
Page.
Yeah. Reimbursement, Milo, kindly also mark the para 6.10, page 122. Reimbursement, because they also stated that I have not given any evidence. In fact, I will show the so-cause notice itself just for a moment, my lord. So-cause notice itself says all detail was submitted. A limitation, my lord, 6.11, page 123. The third issue relating to limitation was answered by the learned adjudicating authority negatively against the appellant. It is noticeable that the appellant has not disputed the nature of the different service provided by is depicted in para 3 herein above. There was a search on this and this date. After that day only, the appellant sought clarification from the authority by letter dated so-and-so as page so-and-so as to whether it was liable under the act seeking registration on this start paying service tax from 2002 onwards. All act of the appellant being made after the date of the search, invocation of longer period prior to the search, whether warranted, and if so, up to which date, call for the scrutiny of various evidence on the touchstone of the law to suggest appropriate action under the law. However, the normal period falling within the impugned period as envisaged by the law should not escape liability. In fact, I again succeed before this court in the infinity case. If the so-cause notice issued for larger period, if larger period is not invocable, there is no question of changing it tenor to the normal period. I succeed before this court. They have given a final, but normal period will not. Whether the extended period.
According to him, the period from 1999 to March 2009, 2004.
2004 March, yes.
So some part of the period falls within the limitation. That is his finding.
Yes, but my submission, which I succeed before this court, once a so-called notice was issued, let's say, assume there was a fraud, and I proved that there is no fraud, then the question to convert that so-called notice for the normal period
doesn't arise. That can't be permitted.
Yes,
so
in fact,
he says that you restrict the show cause notice to the limitation period alone.
No, yes. This finding is that, but the question before my lord, the first section 73, my lord, may be referred. May I give the compilation?
No, we'll go one by one.
Yes.
First, you show the decision where this coal.
The coal handle was reversed. Yes, yes, my lord. Yes. My lord. The serial number 6, my lord. Page number 31, my lord. Page number 31, para 12 or para 13. This judgment, my lord, start with.
It starts at page 28.
28, my lord. Yes. Para 11, 12, my lord, what activity should be covered under this? In fact, the tribunal made a grave error. The tribunal has given a finding. The possession of the goods is not necessary at all while carrying out the activity of the C&F agent, where the original authority said either one could be either clearing or forwarding. Punjab Haryana High Court said no, both should be there. You can't.
And what are the facts in your case?
Yes, my lord, the facts, my lord. Kindly see. It is, my lord, in the SOCO's notice, may I point out from the SOCO's notice, it has been accepted. Kindly come to the page 53.
Have you given a compilation copy to Mr.
Just one minute.
Just no?
I have to go through it, Madam.
Where is the show cause notice?
SOCO's notice, my lord, start from the page 47, my lord. And para 9, my lord, if see para 9, it refer to the agreement, page 50, para 8 onwards, page 53.
Yes.
Yes, accordingly, the service rendered by NKC with remuneration at such that the rate was agreed from time to time under the consignment agency contract agreement so renewed were payable and were continued to be paid by them, sometimes on written request of the customers. Cutting and bundling was also undertaken. Charges, if any, incurred on that count were also reimbursed in addition to the remuneration received by NKC for handling of material in the manner given in the said contract. The clause 5.3 of the said agreement dated 21st December 2002 on various very clearly stipulate the unwaivable terms. The service charges paid to NKC are inclusive of all taxes, including the service tax payable by the Naresh Kumar. This agreement is unloading and handling of all steel material consigned by the TISCO to the Calcutta hub, and thereafter loading the steel material for transportation to the customer premises. The scope of the work as detailed in clause 2 of the agreements are as follows. Naresh Kumar shall receive or dispatch the consignment by rail and by road. Then, my lord, the next clause, the Naresh Kumar shall take the delivery of the incoming material, arrange transport to the yard, stored and stock them after payment, if any, quality-wise, section by section, length by length, in the goods countable order, with intervening the bars in the godown set or on the open yards. Instructed by the Tata Steel, a representative of CR products shall also be stored in a covered shed only. Naresh Kumar shall load and unload the wagon and complete the same within the free time allowed by the railway authorities. Naresh Kumar shall be responsible for damage of any rolling stock of the railway or propriety of Tata Steel. My lord, in fact, 2002, my lord, the cargo handling activity was made taxable. In fact, that plea by noted but never considered either by the tribunal or by the lower authority. The cargo handling activity, my lord, just
Now you are registered with effect from 2002.
I registered because I was compelled to register. Otherwise, I am contesting that amount, my lord, which they have asked me to pay. They have appropriated. I am asking for the refund of that because my proceeding was going on. They said, you pay it and you contest it. In fact, I paid in 2004 the prior period amount when the Jamshedpur DGGI came. I will just point out the cargo handling activity, what scope of that, which the plea which I took, and original authority has also noted that I have taken this plea.
No, I think what you need to do is you prepare a tabulated statement. What are the issues? Which paragraph in the show cause notice or which page in the paper book? What was your reply? In concise, finding of the commissioner, adjudicating authority. Who was commissioner adjudicated the show?
Commissioner.
As against which you went to the tribunal.
Yes, ma'am.
Finding of the commissioner. Then what was your ground of challenge on that point? Finding of the tribunal. With page number, it will be easy.
Yes, I will give a.
If you can do that, because See, technically speaking, if we consider limitation alone as the first issue and you succeed, everything is gone.
In fact, there are direct decision. If the limitations succeed,
If-
need not to go in merit
want,
at all.
But then it is better for the assessee to argue all points
Yes, man.
and take a decision because they will not stop here.
Yes, they will go to the Supreme Court, then the matter will not finish then.
There they will say, no, the High Court erred in not deciding the other issues. send
Yes.
back. So you argue all issues.
Whereas the Honorable Justice Chandrachud, while sitting as a Chief Justice in
Allahabad.
Allahabad High Court, has held that in an excise matter, when the limitation issue is in favor of the assessee, going into the merit is illegality, quoting a Supreme Court decision.
We'll have the matter on Monday. You check your diary.
If my lord permit me, if because I can, if it can be taken up tomorrow, I will just prepare a chart today itself. If it is my lord convenient, because matter is very short otherwise.
All right, we can have it tomorrow, but they will require some time.
Yes.
If you can prepare the chart, give them a copy tomorrow,
Yes.
and the compilation is received. So Mr. Bhattacharya will go through this.
Then Monday, my lord.
Monday we can have it. We have commenced hearing of the appeal. We commence hearing the learned advocate appearing for the appellant assessee. As there are several issues involved, for the sake of convenience, we direct a tabulated statement be prepared containing the issue, the relevant paragraph in the show cause notice, the relevant paragraph in the reply to the show cause notice, the finding of the adjudicating authority, the ground raised before the tribunal, and the finding of the tribunal. If this in this tabulated statement, the page numbers of the
Paper book.
as contained in the paper book shall also be indicated. Copy of such tabulated statement shall be served on the learned advocate appearing for the respondent department, preferably by tomorrow. List the matter on Monday.
Can it be top of the board or
So it will come the same position.
grateful, man? Grateful. We have,
But before that, where did the tribunal say that your services, that because that is the question of law admitted.
yes, my. Yes. Let me point out, my lord, straight to that. Kindly come to the page 119. The 2 points. First, page 119, my lord, this paragraph from the bottom 6-7 line. It is not necessary that the goods should be in the custody or possession of the agent while carrying out the aforesaid operation, because this particular point is contrary to the Supreme Court decision co-lender.
Correct.
And thereafter, my lord, they said, page 120, all sub-activity, even by their different character, if else, shall not oust the principal operation from this being called clearing and forwarding operation. If such sub-activity independently carried out may fall under the different class of taxable service. Fine. 6.9. And in 6.9 finally concludes that page 121. After 5-6 lines from the top, we reiterate that the nature of activity carried out by a clearing forwarding agent, if satisfied with the clearing forwarding operation, that only attract the levy irrespective of the parties choosing to the name and doers in any manner they like. Precisely in 6.8, my lord, in the present case, the appellant appears to be an agent other than the pure agent. And in this paragraph on page 120, the The appellant, it is therefore possibly to hold that the appellant is a clearing forwarding agent providing clearing and forwarding operation services during the impugned period. That is adject finding para 6.8.
Okay.
Grateful.
Number 7.
My goodness. Why you put in single volume, sir? I-
Point is very short point is there, my lord. Whether, my lord, embossing something on the, my lord, footwear, the shoes, whether it is amounts to a manufacturer or not, relabeling, embossing, and giving, my lord, the price on the shoes, whether it amounts to a manufacturer, that is the issue has to be decided by Lord. Say, my lord, kindly come to 485, my lord,
The Central Excise Act.
my lord. Lord, say, kindly come to 486. The points of law, my lord, framed by this honorable court.
But I would be submitting that if this concerns rate of duty, whether there's manufacture or not, and therefore whether duty will get attracted or not.
Directly have a
Yes,
effect on the.
because that point was raised at the time of admission. The court expressed prima facie view, but left it open for decision at the hearing stage.
But clause 3I of section 2F, which will include labeling, relabeling, declaration or alteration of retail price on it, or adoption of any other treatment. That has been explained in several decisions.
Yes.
But here, the tribunal has said that the barcode is only, it is read by the machine. Therefore, it is not that any consumer or customer can make anything of it. All those details are already there on the box. The barcode, it's for inventory, for billing, it serves that purpose. So they said that this there's nothing to the goods. It is just a barcode which facilitates.
Where is the finding of the tribunal?
At page 9, the order starts.
9.
Lordship.
It's 10 minutes. Sorry, 10, 11 minutes.
The other part, before my lords, read it.
See, barcode, unless you have a reader, barcode reader, no person can make anything out of it. It will contain all details. In fact, it will contain details of the factory outlet, which unit it was manufactured. It's all customer, whatever information the manufacturer wants to put in, they'll put in, including the type of leather which was used, place of manufacture, month and year of manufacture, plus the price, retail selling price also.
Hello, here, my lord, not simply a barcode. They're relabeling, they marking the price of the goods there. That's why we're saying, my lord, that section 2A.
Just one more thing before my lords read page 10. My lords, there is a table of the matters before the tribunal. And my lords will find that the first appeal is of Sri Leathers, which is a partnership firm. And the fourth one is of Sri Leathers Private Limited, which is a private limited company. And there's repetitions thereafter. So this appeal is only in respect of Sri Leathers, the firm. The company has not been made a respondent. No separate appeal filed. No separate appeal. And if we look at the individual quantum in each of the matters, because the tribunal clubbed all the appeals, but each of them is less than 2 crores.
If that point come, then my lord, appeal is really, my lord, is no more before lordship, my lord.
Because I checked, each one is less than 2 crores.
So you, so you totaled up all the demands and then you said it is approved. So this appeal is confirmed to appeal 629.
But there are, if we take the firm Sri Leathers, then there's another one 472 of 2010 and 488 of 2010. So these are the 3 appeals.
No, they have filed this appeal against 472, 473, 629, 631, 488, 489.
They have included the firm and the.
No, each individual appeal has to be considered. I mean, because it's a separate order passed for each of the year or whatever. Show cause notice was.
Well, year was
combined notice,
2010. Appeal was 2010, well, all appeals of the year 2010.
Correct. But then when you apply the monetary value, it's a different assessee. One is a partnership firm, one is a company, probably some are proprietorship.
The others are individuals who are employees, they were penalized. So that part is not really.
If I come back on other, because the paper book was also not there with me.
No, there's nothing
Subsequently,
here.
we have got this paper book, voluminous, my lord. But this
Or
is,
we will say matter, it's a factual thing and some judgment the tribunal has referred.
The tribunal has referred to a decision of the Bombay bench of the tribunal.
Hmm.
There was an appeal taken against that before the reference before the Honorable High Court. But there the question originally was regarding barcode, then it was reformulated to speak of brand naming. So that the question decided by the High Court is brand naming. So the barcode was
Barcoding became final.
It was not before the High Court.
my lord, I have got a judgment of Supreme Court of 1995, my lord. They are judgment now. So last दिन जाने की term list पूरी नहीं दिखा था. Kindly see there, my lord. If your lordship, para 4 and 13 of the judgment, if your lordship consider, my lord. Para 4, my lord, if I place, my lord. The definition is thus and in
Paragraph?
paragraph 4, my lord. The definition is thus an inclusive definition. The purpose of the definition is to include certain process and activities within the ambit of the said definition which may not otherwise amount to manufacture and ordinarily understood. This inclusion is in addition to the normal meaning and context of the expression manufacture. The said expression has been subject matter of the several decisions of this court, to which a brief reference to is necessary to bring out the principle enunciated therein.
No. First you refer to the facts of the case. Paragraph 1 of the judgment. No.
Oh, this is
yes. See, even in the head note,
my lord.
whether a process amounts to manufacture is a question of fact. And one of the main tests is that after application of any particular process, the commodity is no longer regarded as its original commodity, but it is instead recognized as a distinct and new article. A shoe does it merely because of labeling and barcoding that the shoe becomes a different commodity. So here, what was the test? This one, facts. Third line, respondent fine chemical engaged in manufacture laboratory chemicals and fine chemicals. Undertake repacking, purification of laboratory. Classification file, they claim the process of purification and distillation does not amount to a process of manufacture, accordingly claimed exemption. Assistant collector agreed with the respondent, but his order was revised by the collector appeal, who held that the respondent do amount to manufacture. Inasmuch as a new commodity known to the market emerges as a result of the process, he held liable to excise. Respondent filed appeal, so and so. One member observed, simple process of distillation, recrystallization does not amount to manufacture. Member judicial took a contrary view. He was of the opinion undertaking is not a simple process. Process brings in a transformation which will change the name, character, and use. Member judicial, ordinarily chemicals, etc., etc. Third member held in favor of the respondent. Now you come to paragraph 4. This judgment is totally inapplicable to your case.
The fourth, fifth line, if your lordship sees, my lord, the respondent cleaned the oil purchased by him by applying certain process and thus obtained refined oil. But the respondent did not apply process of deuteration before hydrogenating the refined oil. The case of the revenue was that even non-deuterized refined groundnut teal oil is refined oil as known to the consumer and the commercial community. The respondent's case, however,
No, sir, please.
My lord, if your lordship, my lord, takes up page 47 once, my lord.
Anjan,
According to me, my lord,
you ask Disha to pass the pledge to. Of the Central Excise Act, 1944, within bracket the Act.
my lord, may I hand up the referring the 10 appeals are there before the tribunal. May I give the details, particulars, CDL 1, 2, 3, 4. I have quoted there.
Okay.
It will help your lordship to pronounce the judgment.
Filed by the revenue against a common order passed by the Customs, Excise and Service Tax Appellate Tribunal, East Regional Bench, Kolkata, within bracket Tribunal, in a batch of appeals, namely appeal numbers, excise appeal numbers 472-473/2010, capital E /629-631/2009 and E/488-489 of 2010 and E/21-23 of 2010, dated 28/7/2011. But this question that will not arise in the appeals filed against the penalty orders.
My lord, there's no question formulated
Hey,
on the
no question has been formulated.
penalty is out, my lord, and it'll be confined to the partnership firm because the company is not. made-
Therefore, it will be confined to appeal 629 of 2010,
472 of 2010 and 488 of 2010.
no, 21 of 2010,
But force in the chart made by the tribunal at page 10, if my lords are pleased.
Mr. Bhattacharjee handed over one,
This chart,
Sir,
472,
আপনাকে দিয়েছি, মোবাইলে দিয়েছি।
472,
and 488.
473,
No, those are companies. My lord.
companies.
Companies have to be excluded, not only the firm. Because no, the company is not a.
We have to decide which
Kindly see the cost item.
cost title.
The company has not been made a respondent.
No, the company was there in, my lord, kindly
Company.
come to page 3, my lord, page 3. Page 3 kindly sees, my lord, company is, Three Leathers is a company.
Three Leathers,
Yes,
senior manager and partner.
partner.
You know that private, Sri Leathers Private Limited is not a respondent before my lords. Therefore, my lord, the list with the tribunal has made of the appeals, my lords, please see that, page 10.
Hmm.
But 629 of 2009 note is Sri Leathers.
Hmm.
So the next two are individuals. Then 21 of 2010 is Sri Leathers Private Limited.
That is not
Not before my lords. Then two individuals. Then
472.
472 the firm, and 473 again the private company. 488 not again the firm. So this was the revenues appeal because the adjudication was in my favor. And the last one is not the company again. So there are three
So
appeals,
only three.
three.
629, 472 assessees appeal
Okay.
and 488 revenues appeal.
And
These are the
21 to 23 also they have, my lord, last.
No.
Page 4. Page
Four.
4, my lord, page 4. Page 4 kindly sees, my lord.
That all right. We will include that also. Though the impugned order has been passed in a batch of appeals, the present appeal relates only to the partnership firm and its partners. Namely, the appeals which were filed by the assessee, partnership firm before the tribunal in appeal number 629 of 2009, the appeals filed by the partners, appeal numbers 22 of 2010 and 23 of 2010, and the appeal filed by the firm in appeal number 472 of 2010, and the appeal filed by the revenue in appeal number 488 of 2010.
489.
The appeal was admitted on the following substantial questions of law.
486, my lord, page.
Admitted on 23/11/2011 on the following substantial question of law. Only one question, sir, at 486. The appeal having not been entertained, having not been admitted with regard to the penalty which has been, with regard to the relief granted to the partners by setting aside the imposition of penalty, have not been, cannot be considered as no substantial question of law has been admitted. Accordingly, the appeal, accordingly, the order passed by the learned tribunal in appeal number 22 of 2010 and 23 of 2010 are dismissed. The short question which falls for consideration is whether affixing of barcode on the goods, namely footwear, received from the suppliers of the assessee would amount to manufacture as per the provisions of section 2 within bracket small f within bracket 3 i's of the Act. The Honorable Supreme Court, in the case of Collector of Central Excise, Bombay versus SD Fine Chemicals Private Limited, explained as to what would amount to what is the clear meaning of the definition of the expression manufacture under section 2 within bracket F of the Act. It was pointed out that section 2 within bracket F, that the expression manufacture as contained in section 2 within bracket F is not confined to the natural meaning of the expression manufacture inverted comma, but is an expansive definition. Full stop. Certain processes which may not have otherwise amounted to manufacture, comma, are also brought within the purview of and placed within the ambit of the said definition by the Parliament. Full stop. It was further held that not only processes which are incidental and ancillary to the completion of the manufactured product, but also those processes as are specified in relation to any goods in the section or chapter notes of the schedule to the Central Excise Tariff Act 1985 are also brought within the ambit of the definition. Further, it was pointed out that the question whether a particular process does or does not amount to manufacture inverted comma, as defined under section 2 within bracket F, is always a question of fact to be determined in the facts of a given case, applying the principles enunciated by the Honorable Supreme Court. Full stop. One of the main tests evolved by the Honorable Supreme Court is whether, on account of the process employed or applied by the assessee, comma, the commodity so obtained is no longer regarded as the original commodity, but is, comma, instead, comma, recognized as a distinct and new article that has emerged as a process as a result of such process. In this regard, we take note of the decision of the Constitutional Bench of the Honorable Supreme Court in Messrs. Ujagar, Ujagar, Paint, Prince and others versus Union of India, 1988 within bracket 38 ELT 535 within bracket SC equal to 1989 within bracket 3 SCC 488. With the above, thus we are required to examine the factual position which has been dealt with the tribunal, bearing in mind the meaning of the word expression occurring in section 2 within bracket F of the Act. As mentioned, as noted above, the question is whether affixing a barcode on the goods by the assessee received from their suppliers would amount to manufacture. The tribunal has examined the factual matrix and found that it is an admitted fact that the assessee does not indulge in any activity of packing or repacking, labeling or relabeling of the footwear. And it is also admitted that the assessee does not adopt any treatment on the goods to render the product marketable to the consumer, which is evident from the fact that they purchase the footwear from individual suppliers on negotiated prices to deliver the same to the assessee in boxes with printing of MRP on boxes and footwear and description in the form of a barcode, etc. This process was examined by the tribunal, and it was rightly pointed out that barcode is nothing but optical machine readable representation of the data which shows certain data on certain products. And such barcodes can be read only by an optical scanner called as the barcode reader using special software. By affixing a barcode on the goods, it does not give any additional information to the customers, as the said barcodes are only readable by machine. Further, it was pointed out that it is a matter of record that a barcode which is affixed by the assessee is only representing the data which is already present on the cardboard box supplied by the supplier. And in the absence of such a barcode, the footwear are marketable to the customers more particularly to the shops in the rural areas which do not have barcode scanner, and the footwear are sold without scanning of the said barcode. The learned tribunal followed a decision of the coordinate bench of the Mumbai tribunal in the case of Rafiq Malik, RAFIQUE MALLICK versus Commission of Central Excise, Mumbai 1, 2006 within bracket 193 ALT 200 within bracket TRI-MU Mumbai bracket close.
বারকোড লাগিয়ে দিচ্ছে কি আছে নতুন কিছু কি করছে
Wherein the learned tribunal followed the decision in the case of Commission of Central Excise versus Manisha International 2003 within bracket 152 ELT 345, Avon Beauty Products India Private Limited 2002 within bracket 83 ECC 52, Panchsheel Soap Factory 2002 within bracket 145 ELT 527, and Lal International Private Limited 2003 154 within bracket ELT 520. I'm taking it from page 15. Now, in this page 15, the extracted portion, paragraph B, the senior advocate referred to senior advocate of
Department, revenue.
set out in this Rafiq.
the learned tribunal noted.
It is part of Rafiq Mullah matter. It's a part of Rafiq matter.
Yes.
Malik.
Senior advocate would mean that for the department. Referred to the zone, so which were relied on by the revenue, but held by and it was held that those decisions will not assist the case of the revenue, as in the said case within bracket Rafiq Malik. It is only It is only MRP simpliciter with barcode labels and logos were being placed. The Decision in Rafiq Malik was appealed against before the High Court of Bombay, and we are informed that this issue was not one of the questions which were admitted for consideration in the said appeal. Thus, considering the undisputed facts as noted by the learned tribunal, we are fully convinced that the learned tribunal rightly allowed the assessee's appeal and granted relief. Thus, for the above reasons, we find no grounds to interfere with the impugned order. Accordingly, the appeal fails dismissed. Substantial questions of law are answered against the revenue.
I'm grateful.
Grateful.
But the interim orders were passed at the time of admission.
One second. This is 21 is company. 22 and 23. That is by the 21 that they have not filed at all. Because in the cost title, company is not a party. Only the firm is a party. Though we have mentioned this is wrong. They will mention everything, departmental number, everything.
But the money which is lying deposited, not kindly take payment 487.
Ah.
But in fact, the money is lying with my client, but they cannot use it at page 487. If my lordship please see. The amount should be set apart and should not be appropriated. So I should be discharged of that obligation.
When the appeal was admitted, an interim order was passed on 23/11/2011. Directing the bank guarantee furnished by the assessee to be returned by the authority.
And the money refunded.
And the money which is refunded, will be received by the assessee, and the amount has to be set apart and should not be appropriated. In the light of the above order dismissing the appeal, the interim direction given by the Honorable Division Bench in the order dated 23/11/2011 stands vacated, and the assessee is free to appropriate the said amount which was refunded and set apart.
Agreed.
So let's say that. No, call one. Contempt is there.
Item number 8.
Tram.
Yes, contempt application arising out of the tram matter, my lord. My lord,
They
here,
don't know who bituminized it.
now, my lord, they are further bituminizing, and my lord, they had, my lord, represented before your lordship in other, when the matter was being taken up, that they were trying to preserve the way which goes through the Maidan. Now, my lord, as it appears, there are reports that they have again, my lord, tried, my lord, the report is that, my lord,
What happened to that committee is nothing is moving.
committee, my lord, last meeting, 13th May, my lord, and
Then what we can do is,
yes,
you serve notice in the contempt.
yes.
We will list the writ petition also along with the contempt.
Fine.
Next, today we are.
There is an order. Your lordship was pleased to, my lord. They had come at and, my lord, submitted before your lordship that one SLP was pending. Your lordship was, my lord, pleased to direct that to mention the matter after the disposal of the SLP.
But it's
Now,
still pending.
It's still pending, but this contempt is arising out of an order which is not impugned in the.
No. See, if the writ petition papers are here,
Yes.
it will be easier.
Yes, yes.
So the learned advocate appearing for the applicant is directed to serve notice on the respondents as well as notice in the office of the learned government pleader. Let the writ petition also be tagged along with this contempt petition. Writ petition in WPOP 12 of 2022. We also be tagged along with the contempt application, and the matter be listed on 2nd September.
My lord. There were two writ petitions. Ours was in the original side, another was in the
No,
appellate
but
side.
then the writ petition is running before the other honorable justice.
Yes, my lord.
Oh,
It
then
has-
we can't. We'll deal with the contempt alone.
Yes,
You strike out that list along with it.
2nd September.
So we'll stop with this and go to appellate itself.
Deeply obliged.
Old list. You send these papers to Jamba. I'm making book one side. I'm collecting all the one side papers. First group is- And my wife is also taking out. That is from those days on our hospitals, they used to have big sales paper. So both my sons, their past time after their dinner is to make and I will take it to the changes. There's a city I wrote this thing.
Appellate side, daily list, serial number 1.
I am for the appellant, Lord. So, why I do not know why respondent filed this.
They have filed some can 2 of
I do not find, Lords. Group 6 matter, Lordship. Why it appear before Lordship?
this can be regularized. And now who filed this application?
I have filed application for clarification.
Ah.
And while I have mentioned the matter before your lordship, while your lordship is taking up group 6 matter, your lordship
What we'll do is that application is not traceable. So we will treat this as the
we
original.
have given photocopy.
Group 6 matter, Lordship. This is another bench matter.
So we can't deal with this, is it?
My lord,
But modification application will come before the same.
Appropriate bench. No, appropriate bench. As per the standing order,
Ah.
Either judge, honorable judge retired or transferred, then to regular bench. This is standing order, Lordship. My lord.
Now who passed this order?
well,
Justice
Justice
Vito
Calcutta,
Talukdar and Justice
Lopita
Lapita Banerjee.
Banerjee.
Oh, both are not here.
Not
Now,
here.
that is
So
why
while-
the regular bench. As per
Well, my lord, your
standing
lordship
order.
is take it up, my lord, the group 6.
Then we'll do one thing. We will say that because the application is not traceable, the
Matter disposal of disposed 2 years ago.
photocopy shall be treated as the original
My lord.
until the original is traced out.
My lord.
Let this matter be listed before the Honorable Division Bench, having determination to
Lordship.
hear Group 6 matters.
Lordship. Grateful, Lordship.
We have heard the learned advocates for the parties. Since the copy of the application in Can 2 of 2025 is not traceable, we have directed photocopy of the said application be filed by the learned advocate for the applicant, which has been done. Let the photocopy of the application be treated as original for the present till the original is traced out. Full stop. Since the matter has to be heard by the Honorable Division Bench having determination to hear Group 6 matters, the registry is directed to list this application before the
Your my lord,
Honorable
Justice.
Division Bench
Not
having
name.
determination to hear Group 6 matters.
My lord.
It will come tomorrow day after.
Grateful, Lordship.
Serial number 2.
My lord, I appear for the appellate, my lord.
Yes, sir. Yes, sir.
I'm sorry, my lord, I am not
Respondent will not,
fortunate
until
present
led
your
by
lordships
Mr.
today.
Pratik Dhar.
My lord,
What they are not willing.
I don't know, your lordship had directed them to
Last
take
time-
instructions.
Last week, we made one proposal.
Yes, but that proposal, my lord,
They are not yet.
is subject to hearing.
Pardon?
My lord, we want the matter to be heard. Whatever,
not
my
at-
lord, is the decision will be, my lord.
Yes, sir.
My lord, in that even, my lord, may I invite your lordships to the two agreements which we have referred to, which are copies of which are already annexed to the stay application. And just 2 or 3 clauses.
That's, my lord, page 481, my lord, in the stay application volume 2.
In the compilation,
No, in the it's not annexed to the compilation.
481, volume 1.
481.
This is volume 1, no?
Given a type copy also, because since the original, the one we found, it's not very legible. This is, my lord, an agreement,
Page 481.
page 481, my lord, is a type copy. This is an agreement, my lord, which, my lord, Indian Oil, my lord, entered into with a contiguous, my lord, leaseholder. Identical, the same project, my lord, same project, same district. So far as the appellants are concerned, no agreement was executed.
Oh,
May I
this is-
place, my lord? Page 481.
Only this one. It is. If he is referring to this agreement, my lord, paragraph 6, if your lordship sees, my lord, 1250 is recorded.
Hmm.
Now, the learned, my lord, the adjudicating authority, my lord, the competent authority has come to a finding that insofar as 1250 is concerned,
They are not getting it.
they
No,
cannot
no,
get-
I am not on that.
Now, if
Well,
they
my
are
learned
pressing
friend,
this-
my lord, Mr. Bhattacharya,
Kindly allow me to place, my lord, I will not place
let me place on my.
You wait
Kindly
for
allow me to
that,
place one. I will not place the entire agreement. Lordship, may I place, my lord? This agreement plus second paragraph. This agreement is made on so and so date, my lord, between IOCL and so and so.
No, you point out the relevant paragraph.
Lordship.
No.
Now, my lord, this is, my lord, this is the first agreement. Now, kindly comes to, my lord, paragraph 6 first. It has been agreed upon that the value of the fish for the whole water body measuring an area of 5720 decimal would be fixed by way of compensation at the rate of 1250 per decimal to the actual leaseholders who actually suffered the loss. Then, my lord, kindly turns over. Kindly comes to paragraph 9. Next page. It has been agreed upon that the drainage of water by the leaseholder must be completed by 31st May 21 in order to provide a smooth gateway to IOCL to start the operation. Then, my lord, paragraph 11. It has been agreed that upon the operation of laying of pipeline will start soon, and after the drainage of water as completed, and IOCL would take up the work and complete it within 45 days. These 45 days will be counted from the date of handing over the fisheries by the leaseholder after drainage of water. Then paragraph 12, my lord. If the work is not completed within the stipulated period of 45 days, additional compensation shall have to be paid by IOCL on pro rata basis. That is, per day compensation will be the ratio of total compensation paid and the number of days involved. Now, my lord, this is the first agreement. Now, similarly, in this case also, my lord, they could not conclude the work because of, my lord, so intervening, my lord, monsoon and my lord, storm. So they entered in the second agreement. That's at page 43. 483, I'm sorry. Next page, 483. Self-same participant and IOCL. I'm reading from the second last paragraph, my lord.
Yes.
That due to the natural calamity in the form of yash, Lordship, got that one? Due to natural calamity in the form of yash followed by heavy monsoon, the task of laying pipelines could not be taken up, although the leaseholders drained out the water of the fisheries in due time within 31/5/2021. The leaseholders now demanded the entire compensation amount of rupees 71,48,350 for the loss of fish, together along with the amount up to current date on pro rata basis, because they could not continue pisciculture. Kindly skips over one page, my lord, the typed copy, page 485. From 16 July 21, after the expiry of agreement date, This may be mentioned here that the previous agreement dated 10/5/21 expired on 15/7/21. Now, after mutual discussions, it has been agreed upon that the laying of pipelines may or may not be possible during the 2 months, that is August 21 and September 21, as there is probability of heavy monsoon. It is not at all justified to pay huge amount of compensation on pro rata basis for the loss of fish when the work has not been started due to flood and heavy rain in this region. On the basis of discussion, arguments with the leaseholders and considering their legitimate claim, a conclusion has been arrived with the consent of the leaseholders that an additional compensation may be paid to them for the loss of fish which amounts to 85 lakh. The time period has been extended up to 30th November 21. This time period will be continued from 16th July 2021 without any interruption or any break. Then, my lord, IOCL reserves the right to enter into the said fisheries at any moment whenever it will be suitable. If the work is not completed within 30th November 21, IOCL authority will pay excess compensation. Now, this is the third time. Will pay excess compensation for the said period after mutual discussion with the leaseholders. No pro rata compensation will be paid for the days which is in excess of the time limit. The leaseholders agreed to allow IOCL extra time period for 7 days after 30th November for restoration and removal of the machineries and accessories without demanding any compensation for it. It has also been decided to pay compensation amount that is 71,48,350. That's the first time, on the date of signing of this agreement. The rest amount of 85 lakh will be paid in 2 equal installments in the month of October and November 21. So, this is how there are similar other agreements also with other legal.
What is your submission based on this?
In
on this basis, my lord, may I make my submission before your lordships, my lord?
Oh.
Your lordship will see, my lord, that at the very beginning of my argument, I had brought it to your lordship's notice that in our case, there has never been an agreement in writing.
Correct.
And in the cases of other contiguous landowners, there was an agreement for the first time, second time, and third time on 3 occasions. In the event the work was concluded within the time period of 2 months, they would not be paid any further compensation apart from what was agreed upon in the first instance.
Sure.
And thereafter, if the work continued, so naturally the IOCL had to pay the additional compensation, or further compensation. Now, the question therefore arises before your lordship is, when the competent authority, having regard to these agreements, came to a conclusion that my clients, having agreed to a sum of which 450 per decibel for compensation for the initial period of 60 days, they could not thereafter increase the claim more than 450 per decibel for the additional period for which they have not been paid compensation. So what had fallen from my lordship was very simple, not that in the event my clients are agreeable to a sum of 450 per decimal for the additional period for which no compensation was paid by us, in that event we will be entitled to make this claim under section 10, subsection 1 of the said act. In the event my clients were not agreeable to this amount of 450 per decimal, then in that event, there would be a case of additional compensation to be decided by the discharge under section 10(2). Now, my lord, it's a well-known principle, my lord, that the competent authority will be entitled to or is authorized to carry out the compensation for the first time, for the first instance. That is the law, which has been laid down in the section 10(1). So at the first instance, it is the additional compensation for the period. Now, in our case, the amount has been fixed by the competent authority at the rate of rupees 450 per decibel. And the period of the claim has been nearly 785 days. And the compensation has also been laid down at 283. There has been no dispute with regard to these claims, neither by the IOC nor by my clients. IOC's MP have not challenged the calculation made by the competent authority. So therefore, we are entitled to the additional compensation for the period beyond the first 60 days, which has not been paid to us. Now, my lord, in that context, my lord, may I invite your lordships to another act, similar act, but of course, the act is no longer there in the Land Acquisition Act 1894. My learned junior will hand your lordships a copy of the 1894 Act before your lordships. Am I audible to your lordships?
Yes.
Your lordship kindly takes CEC 1894 Act and section 28, capital A. Similar set of circumstances. The law was well settled, my lord, that in the event, my lord, some land was taken by the government and that was not challenged, but there was an award which was passed. Then in that event, my lord, in the date of passing of the award, if others who were not challenged, but they were on the same footing as that of the other person, they were also entitled to compensation at the same rate. Now, as you will see, section 28, capital A. So I would invite your lordships to apply this principle as well. I am not asking my lord for additional compensation beyond 450 per decimal. For that, if I am aggrieved, I will have to go before the district judge.
Yes.
But in the first instance, it will be the competent authority which will be entitled to calculate the compensation, and which has already done.
Yes.
And my learned friend, your lordship will see that my learned friend in their opposition has not challenged the calculation made by the competent authority. The only ground was, my lord, that the competent authority had become functus officio, because according to the IOC, the sum of which 42 lakhs and odd was the calculation of the
Sir,
entire period.
that issue has been decided in your favor.
Lordships,
The
absolutely
competent
correct.
authority says that he is not become functus. That finding they have not challenged.
They have not challenged.
You please don't go into that.
Very well.
But
I'll invite your lordships to the final finding of the competent authority that he has granted me a claim of compensation at the rate of 450 per decimal for the entire period of 9.08 acres of land for the period beyond the first 60 days. Till the time it was handed over to my land was
All
handed
right,
over to
sir.
my land in the year 2023.
We will decide that issue.
Your lordship,
Yes.
these are my humble submissions, your lordship.
Yes, sir. Thank you. Mr. Pratik Garve.
Lord, I shall try to be as reasonable as possible. Well, first, two very fundamental facts. If there are two stages under this Pipelines Act, first stages is acquisitions for the use of the land, for which I have to pay. That was done in 2001. Entire amount was paid. There is no dispute on that. So after 2001, because of this land acquisition, that land I would be able to use as and when I need it. For using, in addition to that land acquisition, I also have to pay for the affectation. So there are two stages. First stage was over in 2001. And once this acquisition is completed, if it is a land, then it cannot be made as a fishery. It cannot be excavated. That is what is prescribed under the Act, Section 9(1). It says that. Section 9(1). Kindly have a look at my lord, Section 9(1) Roman 2. Oh, possibly one. Restrictions regarding the use of land. Therefore, post 2001, if it is a land, it should remain as a land because of the statutory bar under 9(1) Roman 2. Construct or excavate any tank, well, reservoir or dam. The entire purpose of myself is not to use it so that he doesn't get a compensation, but to give a picture before your lordship that having paid the entire amount in 2001, when the land remained there, a lease agreement was entered into between the landowner and the petitioner. What was the purpose? Purpose was they did the excavation of the land, they started the fishery, which is completely barred under 9(1) Roman 2, which they cannot do without the permissions. We do not even take this point. We say that when we would be laying down the pipelines, during the time, because lordship may kindly consider that two things. One, I cannot say that I won't be paying any money no matter there is an affectations. That's not the stand of myself. I say that having paid the amount in 2001 for the acquisition, completely settled, having violated, I don't take that point. What do? I find out what is the possible affectations. And having found out, straightway kindly come page 197.
197
of the paper book, stay application. Volume 1.
It is not there in your convenience set.
Well, this convenience I have seen, but I found it was less of a convenience and more of another document. So I thought convenience had to be, if it is more than, I would say 10 pages, then this is hardly a convenience. Sorry. That's it. Yes.
Yes.
So lordship is at page 197. 197 would disclose two things. Thing number one, the entire quantum of affected area. Lordship will find the fishery just after the horizontal first one, next one, second one. It's written fishery and then there is a quantum 378,799. So fishery 378,799, but this 378,799 is the entire quantum. The pipelines would be drawn, but not entirety, some affectations. Now, lordship will find then the name of the petitioner and then right hand side under the compensation amount 42 lakhs and odd. Now this 42 lakhs, there are two things lordship will find just below his name of Subroto, that's a petitioner. Self received paid 50% of the total. Lordship may kindly mark the word total. Why? Decision at the first instance was 42 lakhs for its entirety. But this entirety was not paid then and there. 50% was paid then, and remaining 50%, Lordship will just see rest 50%. So therefore, two interpretations one can try to make. For an example, one may try to say it's a two separate decisions. Because first decision for the 50%, second decisions could be for the remaining 50%. But my respectful submission would be that would be possibly not a correct interpretation. Because the decision of 42 lakhs was the first instance and it is one decision. The payment thereafter was 50% unrest. That has got nothing to do with the decision and the total part. All I am trying to say that the decision of 42 lakhs could be wrong. I am not saying this is right for the purpose of legality. It could be wrong, but this is what the decision for total, number one, and this is the decision at the first instance, which was received by the petitioner. And this is the crop compensation. In this, here is the crop is the fishery. Now, Lordship, kindly visualize these situations. The stand of the IOCL is this. We made you the entire payment of it. You received it. There is a possibility that I was wrong. There is a possibility. I'm trying to think in the way the petitioner should think. In that case, should it be decided again by the competent authority or it should go under 10(2)? I don't say that his door is shut.
Correct.
I say that, and I don't even, though I have said, I made a statement, I made a submission that under 9(1), he could not have made it as a fishery. Because 2000, there is a possibility, I don't know because I was apprised, there is a possibility that if Lordships look at from this point of view, that IOCL is so bad from the day one, they are not even paying anybody.
No.
They are not even, they're giving the land. Well, I can understand.
No, we have got your point. According to you, this is a determination under 10(1).
Yes. Yes.
Payment might have been in 2 installment, 3 installment.
Yes.
Single determination.
Yes.
If he is agreed, 10(2).
Yes.
Subsidiary point is that he could not have done fishery, pisciculture, because it is prohibited.
But this is like, I'm not a bad person, just to say that. I don't want to use that to deny his compensations. I don't want to use it. He was doing the fish.
Could have.
I could have. Just to say that I'm not a bad person.
By invoking clause 2 of the proviso.
Yes. I could have said that you could not have done a fishery because the statute doesn't permit it. Now, what happens, my lord, that every case of affectation of crop is not an watertight mathematical formula. It is not a land acquisitions itself. It is the land acquisitions done, payment made, owner was satisfied with the money with 2001 itself. No difficulty for that. Now, the possible negative point, if I can address. There was an order of the learned single bench. Go before the XYZ for consideration of XYZ document. Now, Lordship, kindly visualize. There are hundreds and millions of matters which come before your Lordships for a simple seeking consideration. When Lordship directs, let that letter be considered, does not mean anything other than taking a decisions either this way or taking a decision that way. To say, even there is a recording that court is not going into the merit of the matter. In fact, my lord, this has some history regarding some clash because, as I was told, there was a vandalisms, officers were beaten up, etc., etc. But that time I said there is no requirement of going into that. There is a letter pending, and he's only asking for. In fact, I myself appear before the learned single bench. I thought that I should be sensible. He's asking only for a considerations. What is the difficulty to acceding? In fact, I do remember I said to my learned advocate on record, let us not agitate because it's a matter of only considerations. So in there you take up all your points, and there then the
So according to you, consideration means on merits and in accordance with law.
yes.
So that does not shut the door of IOCL to raise the question of jurisdiction before the authorities.
Just like the that precisely this is the finding also by the
learned single. We have gone through the entire order. They have placed the entire order. So earlier order in the writ petition is only for a mandamus to consider the representation. It doesn't shut the doors. You are entitled to raise all points which you have raised, which was decided against you. You have come to the writ court.
In fact, I have taken there before the competent authority, I had also taken several points. Lordship will not even find a single sentence dealing with those points. But I am not on that. My fundamental point before your Lordship is this. Once page 197 clearly shows 42 lakhs, I could have understood the word total is absent. I could have understood that his signature contains with his objections, etc. I could have understood that it does not refer to the entirety of the area of the land. Now, he is trying to make out a case of hypothetical, my approach towards some other persons based on some other agreements. What did I do? In fact, if Lordship enters into the deep of it, Lordship will find there was also understanding and settlement. No matter what happens, may I some indicate. From 2001, I can use because of the acquisition. So that is there, but because of my logistics and the policy making, I know that this pipeline will be there, but when everything will happen and I will do that. But legally, that's the land, I would be able to use it. So since 2001, the owner is using in his own way. Now, when we had to do the exact execution of the job, we did so. The execution of the pipeline, that took only for 2 months. And my specific instruction was also that once it had to be dried up for the purpose of laying the pipeline, thereafter, because of the natural process and other reasons, my lord, the fishery continued because it doesn't affect. So all were considered, and thereafter, no, that's it. All were considered, and thereafter 42 lakhs for total was received by the petitioner. His door is open. I don't say his door is not there.
It is including the
entirety.
No, because here in this case, admittedly no agreement. There is only a Panchanama. Panchanama specifies a period. According to them, that period got extended, and therefore they require compensation.
May I just indicate this?
That was the
yes,
case.
I know. I'm aware of that. What they are trying to say, like the Panchanama in a land acquisition proceedings, not the pipelines, where ultimate focus is on use, not it becomes of me. It's not like the land gets vested under the Land Acquisition Act. In Panchanama, here is the case that we will do that. But in reality, that's not the day that we dry up the entire water. That only happens when the pipeline is set up. I am told that just after Panchanama, there was an Amphan for which a devastating impact, and there was a long time, because this pipelines based on a national policy. So it's not that the day it happens, then the next day the work happens. So affectation starts when I actually start working. That corresponds to 42 lakhs, which was found to be the proper. The correctness of this 42 lakhs, my lord, my most respectful submissions can be, of course, challenged and found to be more, not by second time competent authority. In fact, if Lordship reads his order, it looks like he got annoyed for some reasons, and why not much consultation was not made with me. So I don't want to make any statement. All I say, no matter we make thousands of statements, if one sentence of law is opposing that, thousands of statements will simply have to, it must go away. In that light, if Lordship may kindly have a look at just for my satisfaction, Lordship has already seen it. Kindly have it 10, section 10.
To use. Yes.
My lord, in fact, there are always both sides of a story. Always. Like there is a very famous song in our college life. It's by Phil Collins. There is always a both sides of a story. No one is completely correct. No one is completely incorrect. But when Lordship look at the both sides of the story, Lordship will find in this case, the IOCL, they were not absolutely unreasonable. That was the impression I got. Now, in that light, if Lordship kindly come to section 10.
Yes.
The last 3 words of section 10 completely goes against the writ petitioner, and that's the reason the learned single bench was kind enough to pass this order. Kindly see at 10, wherein the exercise of the powers conferred by section 4, section 7 or section 8 by any person, any damage, loss or injury is sustained by any person interested in the land under which the pipeline is proposed to be or is being or has been laid, the central government, the state government or the corporations as the case may be, shall be liable to pay compensation to such person for such damage, loss or injury, the amount of which shall be determined by the competent authority in these 3 words, the first instance. Now, kindly have a look at thereafter. Section 10.3. Yes, correct. Now, thereafter, kindly see, my lord, 2. So, under same section, when there are 2 subsections, one confining to first instance and 2 onwards post first instance, to interpret that no, one still holds the power on first instance, my lord, could be giving a different meaning of the word first. My lord, first has to be understood as in common English we understand the first. It should not be the second one. And kindly have a look at 2. Why it is first and why it comes to 2. If the amount of compensation determined by the competent authority under subsection 1 is not acceptable to either of the parties, the amount of compensation shall, on application by either of the parties to the district judge, within the limits of whose jurisdiction the land or any part thereof is situated, be determined by that district judge. That's the answer. Starting from second to whatever lies with the learned district judge. And the first should mean first. In this case, first is total. So just because, my lord, the 50% amount was paid on a different date, it doesn't make it a second. Lordship may kindly consider.
I think that was not their argument.
I was just thinking that was.
But that is what your submission is right. That the determination was at the first instance a single determination. 42 lakhs plus is a single determination. Disbursal payment is something different.
True.
So you have said that the power under 10(1) has already been exercised. Once again, to send back the matter to the competent authority doesn't arise. If they want,
All points.
they are not satisfied.
Yes.
10-2 district judge.
Absolutely. Absolutely. But only one, there are just since it is on the point of jurisdiction, 3 judgments. One is 2010, 9 SCC 437. Well, I don't need to read it out. This is because paragraph 12 to 14 and 29. It is settled legal proposition that unless the statutes rules so permit, the review application is not maintainable in case of judicial, quasi-judicial orders in the absence of any provisions in the Act granting an express power of review. It is manifest that a review could not be made and the order in the review passed is ultra vires, illegal and without jurisdiction. But then 13, some other judgments have been followed and leaving the judgment portion of an earlier order is impermissible as review
That is clear, sir. It's a creation of the statute. Unless the statute creates a review, there is no review.
Well, a similar point, another judgment, just 2007, 6 SCC 382. 7, 6 SCC 382, paragraph 21 to 22. Paragraph 22, just my lord, below from placitum, between placitum C, D and E. Just my lord, C is to the point, the appellant did not and in fact could not confer upon an authority a jurisdictions which he did not derive under the statute. If he has the jurisdiction post first, I don't have a difficulty.
The next sentence also.
Yes.
Jurisdiction cannot be conferred by consent.
Well, all points, I don't mind that. If he feels that 42 should be much more than that, that should be in accordance with law. Not, but these are my respectful submissions.
Kundu was online suddenly.
All right, you make a submission. They have met your points. You have made it things are clear.
May I give my reply tomorrow then?
Pardon?
Tomorrow. May I give my reply tomorrorow? 10-15 minutes only.
Because the other matters are not able to be taken.
Tomorrow at 2 p.m. your lordship takes up appellate side matters. Then at 2 p.m.
Tomorrow 2 p.m. there is difficulty, sir. All right, let it be retained in the same position.
Because
where is that? Somebody can call senior and find out.
To understand, he was here only.
And what will be your reply submissions you want to make?
Just a reply to my lord.
I was purely on a point of law.
On the question of law.
See, facts you have placed.
Yes, yes.
The single bench order you have placed. You have placed the agreements.
Lordship.
Everything is covered. I don't think
that's the reason I said that only 10 minutes kindly give me tomorrow. See, Mr. Kundu is not here. Let only proper on my
all
part.
right,
The client has engaged him as.
All right. Mr. Pratik Dar, learned senior advocate, as appearing for the respondent, IOCL has concluded submission. For a brief reply, submissions of Mr. Kundu, list tomorrow.
Gotcha. That matter.